That water crosses your land, but it belongs to the community, and as of today, the creek is a managed amenity under association control. That was Diane Voss, president of the Stillwater Ridge Homeowners Association, for 9 years, standing at the bottom of my driveway on a Tuesday morning in the spring of 2019, reading off a laminated card while 2 board members nodded behind her. The creek she was talking about ran through 40 acres. I had owned outright since I bought the place in 2004, and it carried my late wife's name on a hand-cut sign her father had set at the head gate 40 years before that. What Diane did not know, what she never once bothered to check in the 3 years of letters and fines that followed, was that I held the senior water right on that entire drainage decreed in 1911, and that I had spent my career as a water resources engineer for the state, which meant I knew exactly what a senior right could do to everyone downstream of it. So, when a woman in a coral blazer told me my own water was now hers to manage, I did not argue. I went inside and started a folder. If you owned the oldest claim on the only water for 10 miles, and the people trying to take it had built their whole subdivision on the assumption it would always flow, what would you have done? My name is Walter Brandt. I was 61 years old that spring, a retired civil engineer who spent 34 years with the State Water Board running flow models and adjudicating disputes. Before I put in my papers and came home to the parcel my wife Ruth and I had bought when we were still young enough to think we had all the time in the world. For most of those 34 years, my job was to sit between 2 parties who both believed the water was theirs and to find out on paper which one was right. I learned that the truth of a water dispute is almost never in the room where people are shouting. It is in a file drawer, in a county basement, in a decree somebody recorded 100 years ago, and nobody has looked at since. I learned that the loudest claimant is usually the one who never read the file. And I learned to keep my own records the way a surgeon keeps his hands clean, out of habit, before there is ever a reason to. The land sits in a high valley in the mountain west, 40 acres of pasture and aspen with a creek running corner to corner, and at the top of my fence line stands an old earthen dam Ruth's grandfather helped build in the years before the Second World War. He was a homesteader named Asa Coyle, who came into the valley with a team of mules and a survey chain. And the story Ruth told was that he and 4 neighbors moved that earth by hand and horse over 2 summers because the creek ran high in spring and dry by August, and they wanted the water held for the late season. That dam holds back a small reservoir, maybe 9 acre-feet, when it is full. And it was that little body of water, more than the house or the barn, that made me fall in love with the place. The first morning Ruth and I walked the property, before we had signed anything. She took me up to the dam and showed me the head gate her grandfather had set, a cast iron wheel gone orange with rust, and the hand-cut wooden sign beside it with the family name burned into the grain. She put her hand on the wheel like she was greeting an old relative. I think I decided to buy the place in that exact moment, standing at the head gate with her hand on the iron. Ruth used to sit on the bank with her coffee and watch the light come up over the reservoir every morning. In a green canvas chair she refused to replace, even after the arm broke. She passed in 2016, 3 years before Diane Voss ever set foot on my driveway, and I had made her a promise near the end, in a hospital room 200 miles from that water, that I would keep it clean and keep it ours. She was not sentimental about much. She was sentimental about that. The last full conversation we had about the place, she made me say it back to her twice. Keep it clean. Keep it ours. That promise is the reason this story has the ending it does, and it is the reason I never once, across 3 years of provocation, let Diane Voss make me into the kind of man who would foul his own water just to win. The Stillwater Ridge development went in across the county road in 2011 140 homes on what used to be the Halvorsen cattle ranch, with manicured lots and a clubhouse and a community pond they like to call a lake. The whole subdivision drew its irrigation and its decorative water from the same creek that crossed my land, except they drew it downstream of me, below my dam, on a junior right filed in 2009 when the developer first broke ground. I knew this because I had pulled the records the same week the bulldozers arrived, the way an old water engineer cannot help but do. I knew their right was junior. I knew mine was senior by 98 years. And I knew that in the Mountain West, when water gets short, senior beats junior every single time, no matter how many homes or how much money sit on the junior side. I filed that knowledge away and said nothing because there was no fight yet. There was just a new neighborhood and a creek that had run the same way for a century. For the first few years we coexisted, I waved at the lawn crews. I let the occasional kid fish the lower stretch. Then the HOA elected Diane Voss, and Diane decided the creek was an asset the association had failed to properly capture. The first letter came in March of 2019, a week before she ever showed up in person. It was printed on heavy stock with the Stillwater Ridge crest at the top, and it informed me that the association had voted to designate the creek a community water feature, that my dam would need to be inspected for compliance with association aesthetic standards. I read it twice. Then I wrote the date on the top corner, slid it into a brand new manila folder, and labeled the tab in block letters, letter 1. I did not respond. There was nothing to respond to. A homeowners association has authority over the homes inside its plat. My 40 acres were never inside that plat, never annexed, never subject to a single covenant, and the creek was not an amenity. It was a decreed water right older than the state highway that ran past it. Then came the Tuesday with the laminated card, and Diane reading me my own water like a verdict. I want you to picture her, because she is going to be in this story a long time. Mid-50s, coral blazer over white slacks, a pair of sunglasses pushed up into a sharp blonde bob, kitten heels sinking into my gravel, a leather portfolio clutched against her chest like a shield. Behind her stood 2 board members in golf shirts, and behind them, parked on the county road, a black SUV with a vanity plate that read STLWTR1. She finished her card, looked up at me, and waited for me to crumble. "The creek's mine," I said, recorded. "You can check the county, Mr. Brandt," she said. "I understand this is a transition, but the water crosses into community influence the moment it leaves your culvert, and the board has determined it is functionally part of our jurisdiction. We would prefer your cooperation." I would hear that phrase from her 4 more times over the next 3 years, in 4 different settings, and every time it would be exactly as wrong as it was that first morning. I told her again that the creek was mine, and that she was welcome to consult an attorney. She told me the board had already consulted one. Then she got back in the SUV and left, and I went inside and filed a 1-page memo of the conversation, dated, with the names of the 2 men in golf shirts. That was the day the folder became a binder. Here is something I learned in 34 years of water law. People who have never been told no by the physical world believe that authority is a feeling, and that if they project it hard enough, the ground will rearrange itself to agree. Diane Voss had been president of Stillwater Ridge for 9 years, and in those 9 years she had won every argument she ever started, because the people she argued with were her own neighbors who had bought into her covenants and signed her forms and wanted their property values protected. She had never once argued with water. Water does not care about your blazer. Water goes downhill, and it goes to the oldest claim first, and there is no committee on earth that can vote that rule out of existence. She just did not know yet that she had picked a fight with the one neighbor who understood exactly that. The fines started in the summer of 2019. The first was the $400 maintenance share, mailed certified, and I had to drive into town to sign for it, which I think was the point, a small humiliation built into the delivery. I signed for it at the post office counter, with the clerk watching, drove home, and filed it. The second arrived in July, an additional $200 for failure to permit the aesthetic inspection of the dam. I read the phrase aesthetic inspection out loud to Nora at the kitchen table, and she laughed so hard she had to put down her fork, because the dam is a mound of compacted earth with a rusted iron wheel on top, and there is nothing aesthetic about it, and never was. The third came in August, 300 more for an unapproved structure, which is what they had decided to call a dam built in 1938, 11 years before the state even had a dam safety office to approve anything. By Labor Day, the running total the association claimed I owed was $1,100, and I had paid none of it, and I had filed every notice in order with a tab for each, in date order, with a one-line summary clipped to the front of each. $1,100. I want that number to sit with you, because it is going to come back. And when it comes back, it is going to mean something very different than it does right now. My daughter Nora was 16 that summer, and living with me full-time. She had come to stay after Ruth died and never left, and she had her mother's way of seeing. Straight through nonsense. She kept her mother's green canvas chair on the porch and would not let me throw it out either. She was the one who suggested the cameras. We were sitting on the porch the evening the third fine came, the light going gold over the reservoir, the way Ruth used to watch it. And she watched me write the date in the corner of the notice, and she said, "Dad, if she's coming onto our land, should have it on film. You're an engineer. You measure everything else. Measure her too." It was exactly the kind of thing Ruth would have said plain and a little sharp, and it landed the same way. So that weekend, we drove to the farm supply 2 towns over and bought 4 trail cameras. The kind hunters use, weatherproof, motion-triggered, and we mounted one at the head gate, one at the dam, one at the driveway, and one on the barn looking down the fence line. Nora ran the wiring herself and set them to save to a card and to a drive in the house both, and she labeled the folders on the computer in her own hand, by location and date. She was 17 by the end of it, and already thought like a person who would build things for a living. She was right about the cameras. Before the year was out, the footage from the headgate camera would matter more than any letter in the binder. And I would not have had it if a 16-year-old had not told her engineer father to measure the woman in the coral blazer. In October, a man in a tan shirt with a clipboard and a laminated badge walked up my driveway and announced he was there to conduct the dam inspection. He had the bearing of a man who had been told he had authority and believed it. Shoulders back, chin up, the clipboard held at the angle of someone who has watched television. I asked to see the badge. He handed it over with the confidence of a real credential, and I turned it in my hand. It said Stillwater Ridge Compliance Division in the same serif type as the letterhead, laminated at the same shop, and there was no county seal, no state license number, nothing but a logo and a title somebody had invented. There is no such thing as a Stillwater Ridge Compliance Division with any authority over a private dam, and I told him so. I told him he was standing on private property, and that the cameras above his head were recording, and I pointed to the lens on the barn eave. I watched him follow my finger, find the camera, and recalculate. The chin came down. He muttered something about rescheduling and walked back to his car a good deal faster than he had walked up. He left. I pulled the still frame off the camera that night and printed it. Incident 5. I added a note that the association was now manufacturing the appearance of official authority, fabricating a badge, and a division, and a title. And I underlined it once, because in my experience that is the line where a nuisance becomes something a court will care about. A board can fine you all day. The moment they print a fake badge, they have walked into a different body of law entirely. That same month I made a phone call. I'd been turning over since spring. I called the state engineer's office, where I still knew half the staff by their first names, and I asked a young administrator named Pete to pull the full decree history on my drainage and confirm what I already believed. Pete had started the summer. I retired and I had trained him on the adjudication database myself, so he knew the work and he knew me. He called me back 2 days later with the file open in front of him, and I could hear him scrolling. The senior right on the creek was decreed in 1911 to Asa Coyle, Root's great-grandfather, attached to my 40 acres, never severed, never abandoned, current on every filing, with a priority date sitting right there at the top of the page in the careful hand of a clerk who had been dead for 90 years. The Stillwater Ridge right was junior, filed in 2009 by the developer, and conditional on availability, which is the legal way of saying you get water only if there is water left after the senior rights take theirs. Pete said it plainly. Walter, in a short year, you could call the river and shut their water off, and there is not a thing they could do about it but watch the lawn go brown. I thanked him and wrote down the call, the date, the file numbers he read me. I did not act on it. The fight was not ripe, and a senior right is a thing you deploy once cleanly, in front of the right people, not a thing you wave around to scare a homeowners association into behaving. What I knew now for certain was what I was holding and that it had been sitting in a county basement the whole time, decided in 1911, waiting for somebody to remember to read it. Through 2020, the staircase kept climbing. In February, the association filed a civil suit against me in county court, seeking to compel access to the dam and to collect the accumulated fines, which they now put at $3,100. I hired a quiet local attorney named Sam Reyes, a man who had spent 20 years doing water and property work in 3 rural counties and who did not raise his voice once in the entire matter. I gave him the binder. He spent an afternoon with it, turning the tabbed pages, and when he closed it, he said, "You've already won. They just don't know it yet, and frankly, neither does your county. Let it grind." So I let the suit grind. In May, 2 of my longtime hay customers, ranchers I had sold to for 15 years, told me they had received calls from someone at Stillwater Ridge, warning them that buying from me was supporting an illegal operation that threatened the community water supply. One of them, a third-generation cattleman named Earl, was so insulted on my behalf that he wrote out a full page in his own hand describing the call and signed it without my asking. The other did the same. I filed both. In July, Diane stood up at a county planning commission meeting, where I happened to be sitting in the 3rd row in a clean shirt with my hands folded, and described me to the commissioners as a holdout whose unpermitted structure threatened the community's water supply. There it was again, in a public room on the record, with a court reporter taking it down. "Functionally part of our jurisdiction," she said, the very words, "and the property owner refuses to cooperate with reasonable community management." I said nothing. I did not stand up to defend myself, which I could see disappointed the people who had come hoping for a fight. I had Sam request the certified meeting minutes the next morning, because a thing said on the record in a public room is a thing that can be read back to the person who said it, later in a room with a judge in it. It was during that planning commission meeting that I finally understood. The money, and understanding it changed how I held the whole fight. I'd been treating Diane as a petty tyrant with a clipboard, a woman who needed to control her neighbors and had run out of neighbors to control, and that was a mistake, because petty tyrants Do not file civil suits and lean on a man's customers and risk a court reporter. There is money behind that kind of persistence, always. While she spoke, a planner clicked to a slide of the proposed Stillwater Ridge Phase 2, another 90 homes on the upper bench above the existing subdivision, and I leaned forward in the third row and read the engineering note in the corner of the site plan. Phase 2 required a guaranteed water source of a stated annual yield, and the only water within reach that could carry that yield was the creek, my creek, above my dam. Then the planner read off the development entity, and I heard the name, Voss Land Partners. Diane's husband was Gerald Voss, the managing partner of the company. Developing Phase 2, the same company that held the Junior 2009, right? This was never about aesthetic standards or maintenance, shares, or community management. They needed my water to build 90 more houses. A junior right would not carry them through a single dry year. And so they had decided the simplest, cheapest path was to convince me, and the county, and the neighbors, that the creek had always belonged to the association. Until it became true by repetition. The blazer was a costume. The clipboard was a costume. The real thing was 90 building lots worth more money than I will see in my life. And not one of them could legally exist without water. Gerald Voss did not control and could not buy. I went home that night and told Nora what I had seen. She was 17 by then, applying to the State University for Environmental Engineering, of all things, and she sat at the kitchen table and worked it out faster than I did. "So, they're going to keep coming," she said, "because they can't build without it." I told her that was about the size of it. She asked what we were going to do. I told her we were going to keep filing and keep filming and wait for them to do the one thing that would hand me the whole case. She asked what that was. I said, "Something illegal. They're close." They got there in the late summer of 2021. By then, the fine total they claimed had reached $4,200. The civil suit was stalled because Sam had filed my recorded deed and the 1911 decree, and the county could not find any basis for HOA jurisdiction over land outside the plat, and Diane was losing in slow motion. So she stopped waiting for the law and tried to take the water directly. On a Sunday morning in August, Nora came into the kitchen holding the tablet that showed the camera feeds, and her face was wrong, all the easy teenage looseness gone out of it. "Dad, there are men at the dam." I came around the counter and looked at the screen. 3 figures at the head gate. A truck. Motion. I went out to the porch and looked up the fence line with my own eyes and saw a flatbed truck parked at my head gate and 3 men in work clothes with a gas-powered cutoff saw and a chain hooked to the truck bumper, and they were cutting the bolts off my head gate. The cast-iron wheel Ruth's hand had rested on the first morning we walked the place, and rigging the chain to drag the gate open and divert the reservoir down toward the subdivision's intake. The saw was throwing a thin line of sparks. Diane's black SUV was parked behind the flatbed, STLWTR1 on the plate, and she was standing beside it with her arms crossed. She had not sent the men and stayed home. She had come to watch. I want to be careful here, because this is the part of the story where a different man, a younger man, the man I might have been before 34 years of watching disputes go bad, might have done something he could not take back. There was a rifle in the house. I did not think about it for 1 second, and I want that on the record, because the whole point of how I had lived for 3 years was that the paper wins, and the man who reaches for anything else loses, no matter how right he was an hour before. I did not go up the hill with anything in my hands but a phone. I called the sheriff's dispatch and gave the address and said 3 men were destroying a dam on my property with a power saw. I called Sam, and got his voicemail and left the facts in order. I had Nora pull the live feed up on 2 screens in the house and start a separate recording to a 3rd drive, and I told her to stay on the porch and not come up the hill no matter what. And she did not, though I could feel her watching. Then I walked up the fence line, with my phone held out in front of me. Filming my voice as level as I could make it, I told the men they were destroying private property, and that they were on camera from 3 angles. The foreman, a heavy-set man with a sunburn, killed the saw and looked back at Diane. Diane looked at me across my own head gate and said, for the 4th time in 3 years, in 4 different settings, "Mr. Brandt, this water is functionally part of our jurisdiction, and the board has authorized emergency maintenance of a failing structure." Emergency maintenance. They had a saw on my head gate and a chain on a dam built in 1938 and bolts already lying in the dirt, and she called it maintenance. I told her the sheriff was on his way and that everything from the moment the truck turned in was recorded. She held my eyes for a moment, and then she told the men to keep working. A deputy named Cole Maddox arrived 11 minutes later. I had met him once at a county fair, a younger man, careful, the kind who reads a situation before he reacts. He took one look at the saw and the chain and the cut bolts and told the men to step back from the structure. Then he turned to me, and I could see him doing the thing all good officers do, which is trying to figure out whose property this really was and what law applied. He asked me if I could show ownership. I told him the deed was in the house and the water decree was on file with the state. Diane stepped in and told the deputy that the association had jurisdiction and a board resolution, and that I was the one breaking the rules. Deputy Maddox listened to her. Then he said, the thing that constrained officers always have to say, "Ma'am, a board resolution isn't a court order. If there's a property dispute, it goes to a judge. But nobody cuts a structure on land they can't prove they own." He told the men to load their saw. He told Diane the matter was now a criminal complaint for destruction of property, and that she would be hearing from the county. And he told me to bring my documents to the courthouse Monday morning. That was the day the case stopped being civil and became criminal, and it was the day I knew the water right would finally have its public room. The hearing was set for a Thursday in October of 2021 in the county courthouse on the criminal mischief complaint and the consolidated property dispute. Sam told me to bring everything. I brought the binder, 3 years thick by then. And I brought one more thing I had requested from the state engineer's office 2 weeks before. A certified copy of the 1911 decree with the seal pressed into the corner. Nora came too, in a blazer of her own, and sat in the front row where I could see her. The courtroom was full because Diane had made it full. She had spent 2.5 years telling the neighbors I was the obstacle to their water, the holdout, the man whose stubbornness threatened their property values and their decorative lake. And so 40 of them came that Thursday, expecting to watch a holdout finally get put in his place. They filled the gallery in their good clothes. Gerald Voss sat directly behind his wife in a charcoal suit. The first time I had ever seen him in person, a heavy, prosperous man who did not look at me once. Diane wore the coral blazer. I had come to think of it as a uniform she put on to go to war, and she had put it on for what she believed was the day she would win. When the judge asked the association to present its basis for authority over the creek and the dam, Diane's attorney stood and spoke for 10 minutes. He talked about community standards and water features in the board's resolutions and the reasonable expectations of 140 homeowners, and Diane nodded along beside him, certain, her chin up at the exact angle the fake inspector had held his 2 years before. The belief that authority is a feeling projected hard enough. Not once in 10 minutes did the attorney say the word priority. Not once did he mention a date earlier than 2009. He did not have one to mention, and I do not think he knew yet that he did not have one. Then it was Sam's turn, and Sam did not make a speech. He had told me in the hallway that morning that the worst thing you can do with a winning document is talk over it, that you lay it down and let the room read it and let the silence do the work. He laid 3 documents on the clerk's table and asked that each be entered into the record: my recorded deed to the 40 acres, the legal description showing the parcel had never been part of the Stillwater Ridge plat, never annexed, never burdened by a single covenant, the certified 1911 water decree, the seal pressed deep into the corner, senior, right to the entire drainage, attached to my land in the name of Asa Coyle, never severed, never abandoned, priority date, and a flash drive with the camera footage. From August, the saw on the head gate, the bolts in the dirt, the chain on the dam, Diane standing beside the flatbed with her arms crossed, telling the men to keep working after I had told her the creek was mine. He asked the judge to compare the 2 dates. The association's right, 2009. My decree, 1911. He said it once in a level voice and sat down. The judge read the decree. She read it slowly, the way you read a thing you intend to rely on, and the room was quiet enough that I could hear the courthouse clock down the hall and the small sound of Nora breathing beside me in the front row. I watched Diane in those seconds. I watched the certainty hold on her face out of pure habit, the way a building stands for a moment after the supports are cut, and then I watched it start to go. The judge set the decree down. She did not look at me. She looked at Diane and at Diane's attorney, and she asked one question, plainly. The only question that had ever mattered in 3 years. Counsel, did the association verify the seniority of its own water right before authorizing what this footage shows? There was no answer to that question. The attorney looked at his client. Diane looked at the table. In 9 years of running Stillwater Ridge, in 3 years of letters and fines and a civil suit and a fake badge and a saw on my headgate, Diane Voss had never once read the document that decided everything, because it had never occurred to her that a sheet of paper, recorded in 1911, in a hand that had been dust for a lifetime, could outrank a living woman in a coral blazer with a board resolution in her portfolio. The water had been spoken for since before her grandparents were born. She had simply never gone down to the basement to look. The judge ruled from the bench. The creek and the dam were mine. The senior right was confirmed in Superior. The association had no jurisdiction over my land. The fines were void, and the criminal mischief complaint would proceed against the individuals who authorized the cutting. She entered one number into the record that I will carry the rest of my life: fines I had paid. The association, across 3 years of pressure, 0. And then the other number landed on its own over the following months. Phase 2. 90 homes could not proceed without a guaranteed water source, and the only water was a creek now confirmed under a senior right its developer did not hold and could not buy, because I would not sell. The development that needed my water to exist could not exist. 90 lots, gone, against $0 I had ever owed. I had thought that was the end of it. It was not quite. There is one more piece, and it is the reason for the title of this story, because the law had settled the creek, but it had not settled the dam downstream that the subdivision relied on to hold their decorative lake and stabilize their own intake. That dam, the lower structure, had been built by Gerald Voss's company in 2011 to hold the subdivision's decorative lake and stabilize their own intake, and it was failing inspection, the spillway undersized and the embankment seeping. Exactly the kind of cheap construction a developer puts in when he assumes the water above it will always be there to make it look good. And it sat on a small parcel the company had let slip into tax default during the lean years of the lawsuit, when the legal bills mounted and Phase 2 stalled, and the money that was supposed to come from 90 new lots never arrived. In the spring of 2022, that parcel, dam and all, came up at the county tax sale, posted on the courthouse door with every other delinquency. I sat in the back of the same courthouse where the judge had read the 1911 decree. And when the parcel came up, I raised my hand and I bought it. $1,100. The exact figure the association had first claimed I owed them in the certified letters of the summer of 2019. I wrote the check at the clerk's window where Diane had once been so certain her board resolution would carry the day. I owned the dam that controlled their water now, lawfully free and clear, and I held the senior right on the creek above it. And for the first time in 3 years, Diane Voss had nothing to read off a laminated card. I did not drain their lake. I want to be clear about that, because the lesson at the end of this depends on it. I am not in the business of doing to people what was done to me. I held the senior right and I owned the lower dam, and I sent the association one letter, on plain paper, informing them that the structure would be maintained to state safety standards at my expense, and that their decorative water would continue to flow exactly as the decree allowed, no more. The difference was that now it flowed because I permitted it under the law, not because they had seized it. Diane resigned from the board that summer. Gerald's company dissolved Phase 2 and sold the upper bench to a rancher who runs cattle on it. Now the vanity plate disappeared from the county road, and the creek kept running corner to corner across my land, the way it had since before any of us were born. Nora graduated that next spring and started at the State University in the fall. Environmental engineering. First in her class through the first year, the same field her father retired out of, and the same instinct her mother had for seeing the truth of a thing before anyone said it out loud. She came home that summer, and we carried 2 cups of coffee up to the bank above the reservoir, to the spot where her mother used to sit in the green canvas chair with the broken arm, and we sat in the early light the way Ruth had every morning of the years we had together. The water was high and still and clean. Nora looked at it for a long while, and then she said the thing that closed the whole circle for me. Mom would have filed it too. She would have. She came from the man who moved that earth by hand in 1938, and she had made me promise at the end to keep the water clean and keep it ours, and we had. Against 3 years of a woman who never once thought to read the paper that decided it. We watched the light come up over the water. Asa Coyle impounded the year before the war, the water I promised Ruth I would keep, and it was clean, and it was ours, and the woman who tried to take it was gone. Here is the lesson, plainly, because that is the only reason I tell these. If you own water, or land, or a structure that somebody with a clipboard decides they want, the fight is not won by being the loudest person on the gravel. It is won before it ever starts, in the county recorder's office and the state engineer's files. Pull your deed and read it against the actual ground. Find out the date your water right was decreed and whether it was ever severed. Because in the West, seniority is everything, and almost nobody checks. Photograph every notice, save it to 2 drives. When somebody tells you a thing is functionally part of their jurisdiction, ask them to show you the document and then go pull yours, because the older, cleaner paper wins, and the person waving a board resolution at you has almost certainly never read theirs. Keep the binder. Install the camera. Verify the deed against the ground. The water always goes to the oldest claim, and the records were decided years before the argument ever reached your driveway. If you have ever had an association, a board, or an office try to take something that was lawfully yours, Tell me about it in the comments, because I read them and I learn from everyone. Subscribe if you want more of these, because there are a lot of them, and most of them. Turn on a piece of paper somebody forgot to read. Next time I will tell you about the rancher, whose HOA tried to condemn his only access road as a community trail, until he produced the easement his grandfather had recorded the year the road was built. Until then, pull your deed and read it.